So I will be sharing to you today my reading regarding a Supreme Court decision, a case involving squatters, intruders, recovery of possession, recovery of a land, no? So this case originated before the MTCC, Municipal Trial Court in Cities, or Municipal Trial Court. This was brought all the way up to the Supreme Court, obviously because this is a Supreme Court decision that I'm reading to you. So before the Supreme Court is a petition for review on certiorari under Rule 45, the Rules of Court. Okay, what is Rule 45? I'm sure if you have been listening to my previous videos, you've heard these statements several times. Okay, I will just read to you briefly some of the important points of the rules. Okay, Rule 45 is appeal by certiorari to the Supreme Court. Section 1 of this rule is the filing of the petition with the Supreme Court. A party desiring to appeal by certiorari from a judgment or final order or resolution of the Court of Appeals. Okay, because usually not only the Court of Appeals, it can also come from the Sandigan Bayan, the Regional Trial Court, or other courts whenever authorized by law, may file with the Supreme Court a verified petition for review on certiorari. The important part here is that the petition shall raise only questions of law which must be distinctly set forth. Because in cases, typically you have two questions of fact, questions of law. It is not all the time that both questions are present. Sometimes the facts are not disputed, so there are only questions of law. Sometimes the law is clear and easy to interpret, so it is only a question of fact. Okay, and sometimes the facts are not clear, the law is not clear, so you have both questions of fact and law. Okay, so if you raise only questions of law, your remedy could be, okay, because it is these rules are complex, no? You have to read one rule together with the other rules. So this is just a quick read. Okay, so Rule 45, you can raise by way of a petition, verified petition for review on certiorari to the Supreme Court, but you shall raise only questions of law which must be distinctly set forth. So it must be clear. So in this case started before the Municipal Trial Court in Cities, elevated to the Regional Trial Court, then the Court of Appeals. From the Court of Appeals, Rule 45, appeal by certiorari to the Supreme Court. So that was the remedy. From the Regional Trial Court to the Court of Appeals, if my memory is correct, that is Rule 42. Okay, so the time for filing, usually when you lose a case before the Court of Appeals, according to the rules, the petition shall be filed within 15 days from the notice of the judgment or final order or resolution appealed from. So from the time you have received your final order or resolution, this refers only to a final order, because sometimes you receive an unfavorable order but that order is not a final order. You should make there should be a distinction made between a final order and an interlocutory order. Okay, so the rules dictate the contents of the petition, dismissal of the petition, and also the other nitty-gritty, no, to ensure that your case appealed to the Supreme Court by way of certiorari will be granted. Because usually in these types of appeals, no, gamayng sipyat, no, very minor error. Like for example, there was this time that there was a situation where I have encountered the petition that you will submit, no, to accomplish this appeal by certiorari to the Supreme Court. It must be a verified petition. It could be, no, that let's just say somebody else notarized the verification, because the verification will be attached to the petition. That will make the simple petition a verified petition. Okay, the details of the notary was not clear, no, it cannot be read back. Like usually, especially if the stamp is very old, so blot na kayo ang ink, no? That can cause a dismissal of a simple appeal, no? You have your appeal by certiorari consists of hundreds of pages, and it will be dismissed by just one page. So you have to be very careful with the procedures and the nitty-gritty under Rule 45, no? This Rule 45 that I'm reading now, it is copied from the old rules. These rules, when you look up these rules, like the time to file the appeal, you have to check the latest if there are circulars, amendments, to be sure that the number of days to submit your appeal is within the prescribed period. Because if you file it on the, let's just say, it should be filed within X number of days, let's say 10 days, and you filed it on the 11th day, nasayo pagihap ba, or nalipat ka, possibly, that will be the cause of the dismissal. Okay? So this appeal by certiorari to the Supreme Court under Rule 45, raising questions of law, it questioned the Court of Appeals decision. Recall, I have mentioned earlier, this case started before the Municipal Trial Court, specifically MTCC, Municipal Trial Court in cities. Then it was elevated to the Regional Trial Court, then the Regional Trial Court to the Court of Appeals to the Supreme Court. Okay. Before the Supreme Court, the decision of the Court of Appeals was questioned. Okay, because this decision of the Court of Appeals, a joint decision, reversed, set aside this Court of Appeals decision, set aside the joint decision of the Regional Trial Court and the omnibus judgment of the Municipal Trial Court. So briefly, so that you will understand what I'm trying to say, there was a favorable judgment before the first level sa MTCC. There was a favorable judgment when it was appealed before the Regional Trial Court, because the Regional Trial Court affirmed, no, with modification, the decision of the Municipal Trial Court in cities. However, when it reached the Court of Appeals, it reversed the decision. So it said, the Court of Appeals stated that, shortly put, the Regional Trial Court and the Municipal Trial Court were wrong. Okay, so it reversed the decision of the two lower courts. Now, the Supreme Court has to decide who is correct. Is it the Court of Appeals or the Regional Trial Court and the Municipal Trial Court in cities? Okay. The Regional Trial Court, it is a joint decision, meaning there is one decision for resolving two issues. In the Municipal Trial Court, there is also an omnibus judgment, meaning omnibus is it's kind of like there is a single judgment, but it involves several diverse subjects, no? Diverse disputes. So this involved originally 5 consolidated cases. So meaning when you hear this phrase 5 consolidated cases, what will come to your mind would be there are several complaints, 5 complaints filed differently, possibly different complainants, different lawyers. Because if there's only one lawyer for several complainants, there would only be one complaint, possibly, no? Because if you're the lawyer, you have 5 complainants, why file one complaint each? So it is unlikely. It is not impossible, but it is not unlikely, unless you were hired by different complainants at different times. So possibly you file a complaint for the first complainant, after 2 months you were hired by another complainant, you filed another complaint. So since in the complaints in this case, for the 5 consolidated cases, they had uniform allegations, so possibly the evidence, the witnesses, the documents, the issues for the 5 cases are very related or linked, or very similar and uniform. So they were consolidated, so that in the spirit of efficiency, the 5 cases will be tried only once. Okay? Dili magbalik-balik yung witnesses, dili ka magbalik-balik o present sa imong mga documents. It will be presented once for the 5 consolidated cases. Okay. So what are the pertinent factual and procedural antecedents of the case? Okay. Let me read a portion of the decision. Let's not mind the names and the dates anymore. Okay. What is important would be the nice to know the principles in the cases, the lessons in these cases, in these decisions. So the 5 petitioners who filed the 5 separate complaints filed an action for action publicana. So this is the type of recovery of possession. Okay, so this will be distinguished later on. I think later on the later part of the decision, we will distinguish action interdictal, action publicana, and action reivindicatoria. Okay, so these are different types of recovery of possession, but the reliefs are more or less the same, but the grounds and the causes of action are quite different. Okay, so this is a recovery of possession case against certain respondents, okay, certain persons. The suits were subsequently consolidated. Recall, these were initiated by 5 complaints. Subsequently, they were consolidated. They were filed before the municipal trial court in cities, Raffle. Okay, so 5 complaints consolidated, so 1 trial for action publicana or recovery of possession, because there were uniform allegations. So possibly the evidence, the witnesses are also the same. So in the spirit of efficiency, the 5 complaints were consolidated and tried once. Okay. So the uniform allegations in the complaints was that they were the owners of 3 parcels of lands denominated as lot numbers 1, lot number 2, lot number 3. Okay, let's keep it simple. Which are all located in Barangay ABC, Barangay ABC, XYZ City. Okay, Surigao City mo ni. So they inherited the lots from their predecessors in interest, si Lolo. They were in possession of the said properties prior to and at the start of the Second World War, but lost possession thereof during the war. Okay. So these types of cases in principle are easy. What is difficult here sometimes is to prove, because especially if we goes way back years ago, the witnesses are mostly dead, no? Because the witnesses can only testify what they actually saw, what they actually heard, what they actually perceived, no? Tasted, touched, felt. Okay, so they inherited the lands. They were in possession of the said properties prior to, so meaning before and at the start of the Second World War, but lost possession thereof during the war, which is understandable. After the war, they discovered that the subject properties were already occupied by several persons. So there are now adverse occupants, okay, which prompted them to file separate cases for action reivindicatoria and recovery of possession against these persons. So the occupants, intruders, the adverse occupants. So pagkahuman sa gubat, nanay gapuyo lain, no? Ilang gipapahawa, ilang gikiha. During the pendency of these cases, respondents entered different portions of the same properties and occupied them without the knowledge and consent of the petitioners. So according to the landowners, they did not know, they were not notified, they were not aware, and they did not give their consent to the occupation or possession of these intruders. Okay, so they occupied them without knowledge of the owners, and they entered different portions of the same properties. Okay, because possibly squatters, no, the entry was gradual, and they built their, let's say, huts, hut or houses, no, possibly made of light materials, usually, no, at different portions of the land, because maybe they found the land to be vacant and nobody was actually tending to the land, so they just occupied it. So they were forced to tolerate the illegal occupation of the respondents, as they did not have the sufficient resources to protect their property at that time. This is understandable, no? Magpakural kang property, to fence, to build, to erect, to construct a concrete perimeter fence. That is not very easy. And I have also even experienced once, not mine, but I saw it happen, no? There was already a concrete perimeter fence. The property was fenced completely with a concrete perimeter fence. The intruders by stealth, made a hole at the rear portion of the property where it cannot be seen easily by the owners, no? Unless you go around the property, and they place a gate and lock the gate so the owners can no longer enter the property. So even if you fence the property, it is not that easy, no? So they did not have sufficient resources at the beginning, okay, to protect their property, and at that time, and also because their ownership was still being disputed in the earlier cases filed. So before this recovery of possession, there are other cases involving the issues with respect to ownership. In this case, the issue is with respect to possession, okay? So subsequently, the cases which they earlier filed were decided in their favor, so they won these cases with respect to the ownership. Bottom line, they secured the decision stating therein that they are the owners of the properties, and they were declared the owners of the subject properties, sakto jud. Thereafter, petitioners, the complainants, demanded that the respondents, the illegal occupants, vacate the said properties. Well, obviously, we reached the Supreme Court, they reached the court, so these illegal occupants refused to vacate. We don't have to guess anymore. What was the defense of the illegal occupants? Okay. So let me read a portion of the decision. In their answer, the respondents raised essentially similar defenses, contending in essence that they have been in possession of the subject properties for more than 30 years. These petitioners, the complainants, never actually possessed the said parcels of land, and that they never had title over the same. Thus, the claim of the petitioners, the complainants, would be in conflict with and inferior to the respondents' claim of possession. So according to them, we possess this land for a very long time, and these persons claiming to be the owners, they do not have title over the land. They have never possessed this land in the first place. So not so easy, no? They have a defense also, considering that it is more than 30 years. So the possible theory here, I'm just not sure, but the possible theory here is the extraordinary acquisitive prescription, no? Whether you are in good faith or in bad faith, if you are in possession of a land, no? Open, continuous, exclusive, notorious possession and occupation of the land. Even if you are in bad faith, you knew that Juan is the real owner, but Juan is not here, and if the land is not titled, it is susceptible to acquisitive prescription. So that might be the theory here. That is the reason why the magic figure 30 is alleged in their answer. Okay, that is just my speculation. We cannot read the mind of the counsel and the respondents. Okay. So after the issues were joined, trial ensued. Okay, issues were joined. So the issues meaning the complaint alleged their position, the defendants alleged their position in their answer. So the issues, unsay gilalisan ba with respect to the facts, what is disputed with respect to the facts, with respect to the law. Okay, so these are the issues. Once these issues are joined, no, what usually happens would be pre-trial, Rule 18, then trial once the pre-trial order is issued. So trial ensued. So in this case, nothing significant during the pre-trial because the decision did not mention it anymore, no? It proceeded immediately to trial. So according to the Municipal Trial Court in cities, judgment is hereby rendered in favor of the plaintiffs, the complainants, okay, the petitioners. So they won, and the illegal occupants, the intruders, they were ordered to vacate the premises of the lots respectively occupied by them, because remember, they occupied different portions of the land, and to remove their improvements from the premises and restore possession to the plaintiffs. So this is the typical decision in recovery of possession cases, and this is the typical relief you pray for. What you place in your complaint, there is a prayer, the prayer that you are asking for the relief from the court. This is what you usually allege there. to issue an order or a decision for the occupants to vacate the premises on the lots respectively occupied by them, and to remove the improvements from the premises, and to restore possession to the plaintiffs. No? So, sigurista pa juga to deliver the possession to the plaintiffs, to vacate fully, and to relinquish any form of possession over the property. Okay? Para sure, but it's not actually necessary. The defendants, the occupants, were even ordered to compensate, no? Morabag giparent pa. They were asked to pay compensation for the use of the property. But usually, if these are squatters, unless they have jobs, they are financially well, these orders for compensation are almost useless. How can you make them pay if they barely even eat, no? Unless they are rich or they have good jobs, but they just love to squat. No? And all the defendants were ordered to pay the cost of the suit, attorney's fees, litigation expenses. This is usually justified when it is very clear that the defendants do not have a right. Nagpagahi-gahi lang ba? Their refusal was unjustifiable. It would be different if these types of punishment, no, orders to pay the cost of suit, damages, compensation. Usually, you are not ordered to pay these if, like, your defense has merit. It just so happens that you lost, but you thought all along that you were correct. But in this case, it appears that the defendants are just raising defenses, but actually, the court might was thinking that the defenses are just very flimsy, no? Very unmeritorious or unproven, unsubstantiated. Okay, so the landowners won before the MTCC. They were declared the true and lawful owners of the properties. Okay, so the municipal trial court held that in the earlier case of action reivindicatoria, decided by the regional trial court and affirmed by the Court of Appeals. This is a separate case, not this case, okay, which became final and executory. The petitioners, the complainants, plaintiffs, they were declared as the true and lawful owners of the subject properties. On the other hand, evidence showed that the respondents were mere intruders, squatters, on the lots in question. Thus, as judicially declared legal owners of the said lots, petitioners are entitled to possession thereof. Okay? Because that is the benefit of being an owner of the land. Possession, enjoyment of the land. As against the intruders, the respondents, whose entries into the said properties are illegal. Okay? So, after the municipal trial court, it was elevated to the regional trial court. Who elevated it to the regional trial court? Well, the obvious answer, although not all the time, is the losing party. Because sometimes you might win before the municipal trial court, but you do not like the decision. You won, but maybe the decision, you are not satisfied as to how the decision was written. You can choose to elevate it to the regional trial court. So here, the losing party elevated the case to the regional trial court. Okay, and the regional trial court issued a joint decision which affirmed, but with a modification, the omnibus judgment of the municipal trial court. Okay, so there is a modification as to the judgment against the defendant, some of the defendants, because some of them did not file an appeal. Okay? That is just the difference. Okay, so the petitioners won before the municipal trial court. When the losing party elevated it to the regional trial court, the petitioners won again. Of course, you don't stop, no? So, you elevate it to the Court of Appeals under Rule 42. Okay, quick read. Okay, let me read a portion of Rule 42. What is this rule? This is a way for a method of elevating a case to another court, okay, for review. Rule 42 is petition for review from the regional trial courts to the Court of Appeals. Okay. Section 1, how appeal is taken, time for filing. A party desiring to appeal from the decision of the regional trial court rendered in the exercise of its appellate jurisdiction may file a verified petition for review with the Court of Appeals. So remember, the regional trial court in this case acted as an appellate court because the court with the original jurisdiction where the case was initiated was the municipal trial court in cities. So it was elevated to the regional trial court. So the regional trial court in this situation was not acting on the case in its original jurisdiction. It was acting on the case on its appellate jurisdiction. Okay. So you can use Rule 42 if the regional trial court decided a case on its appellate jurisdiction. But if it decided on the case in its original jurisdiction, Rule 42 will not be the proper remedy. What is Rule 42? Petition for review from the regional trial courts to the Court of Appeals. Still, it is a verified petition, paying at the same time to the clerk of court the docket and other lawful fees. Hindi man dyan na mawala, no? Fees are always present. And depositing the amount pesos for costs and furnishing the regional trial court and the adverse party with a copy of the petition. Furnishing meaning you serve them a copy of the petition. So the petition shall be filed and served within 15 days. Okay. I don't know if this is updated. Okay. From notice of the decision sought to be reviewed or of the denial of the petition's motion for new trial or reconsideration. So you count that period from the denial of your motion for reconsideration. Because when you lose before the regional trial court, you still file a motion for reconsideration or motion for new trial. If that motion was denied, you elevate it to the Court of Appeals by way of petition for review from the regional trial courts to the Court of Appeals. Rule 42. Okay. Now, enough on procedure. So let's go to the substance again. So the Court of Appeals promulgated its decision granting the petition. So meaning the decision of the municipal trial court, the original jurisdiction, the court with the original jurisdiction, the decision of the first appellate court, the regional trial court, both decisions of both these courts were reversed by the Court of Appeals. Okay. So now, obviously, it will be elevated to the Supreme Court, and we have to guess whose decision is correct. Is it the municipal trial court's decision and the regional trial court's decision? Is it the correct decision? Is it the correct ruling? Or is it the decision of the Court of Appeals that reversed and set aside the decision or ruling of the Court of the municipal trial court in cities and the regional trial court? Okay. Coffee sa taas na. Okay, so it dismissed the cases for lack of merit according to the Court of Appeals. It set aside the omnibus judgment of the municipal trial court in cities, and it reversed the regional trial court's joint decision. Okay, so thrilling, no? Usually this is difficult to achieve because especially if the municipal trial court in city and the regional trial court has the same decision, sometimes it's difficult to reverse it before the Court of Appeals, especially if the issue is factual issue, like appreciation of evidence, no? Who told the real story, especially if there are two contradicting versions of the stories. Who one said that it was self-defense, Pedro said that no, who one attacked me with the knife, no? So those are two conflicting versions. Was there really an attack or was it a self-defense? So if that is a factual issue, it's very difficult to reverse, no? Swerte. But if it is a question of law, I think it is easier because the facts are established. It will be more on the interpretation of the law involved in the case. Okay. So what was the ruling of the Court of Appeals? The CA, the Court of Appeals, ruled that the RTC and the CA decision, that the RTC and the CA decisions, okay, the previous decisions from the previous cases used by the municipal trial court in cities in holding that The petitioners in this case are owners of the subject properties and are thus entitled to legal possession thereof, are based on a previous action reivindicatoria, okay, which is a suit in personam. It is a personal it is a suit in persona, meaning action in personam, okay. So the Court of Appeals held that being an action in personam, which is personal in nature, the judgment in the said case binds only the parties properly pleaded therein. Okay, this is this is also a good reasoning, no? Because although this was spoiler alert, the Supreme Court did not support this, but usually when you file a case, a complaint, when you file a complaint, the next step that will happen would be Rule 14, Section 1, summons. When the case is not dismissible on its face, when the complaint is not dismissible on its face, the clerk of court has the duty to issue summons under Rule 14, Section 1. So, in a civil case, typical as a general rule, the court acquires jurisdiction through the service of summons, either by personal service, substituted service, or by publication. So, after that, the defendant would answer after he receives the summons within the prescribed period. Okay. So, the decision of the case would only bind the complainant and the defendants who received the summons, no? Because sometimes, like for example, in a case for recovery of possession, there are 20 defendants. The 20th defendant has had his house in this lot 1 to 3. However, his house was there, but only his dog was present at the house, actually occupying the house. The 20th squatter of the lot is actually let's just say a lawyer in the US, residing in the US. So you cannot serve summons by personal service or substituted service. It should be by publication. So if that 20th squatter did not receive the summons properly, the decision of the case would not be binding upon him in this type of case, assuming that it is an personal action, an action in personam. Why? Because he was not given the opportunity to answer the complaint. He did not have the right to be heard, and the court does not acquire jurisdiction unless there was a issuance of service of summons by way of publication. Okay. So, okay, enough procedure. The Court of Appeals held that being an action in personam, the judgment in the said case binds only the parties impleaded therein, meaning only the parties in the action. Okay, it will not include persons like the defendants in this case, because they were not defendants in those other cases that were filed ahead. Okay, those prior cases, the defendants here were not part of those other cases, so it should not affect them. It should not affect their rights. It should not affect the decision in this case, because they were not part of that case. They did not have the chance to defend themselves in that case. So why will that case affect them? Why will that case affect this present case? Why will the prior cases affect this present case? Considering that the defendants in these cases, the defendants in this case were not part of those prior cases. Okay, so that is the gist. Okay, the longer version. Supposedly pa-move on. Since the respondents were not parties to the said action, okay, mao din eh. So it was also explained. The Court of Appeals concluded that they could not be bound by the judgments declaring the petitioners as owners of the disputed properties. Okay, so the spirit behind that is because the defendants cannot be bound because they were not able to fight for their right, if there is even any, in those prior cases. They were not given summons, they were not given the chance to answer, they did not have the right to be heard, they did not have their day in court to fight for what they think is right in those prior cases. So the decisions in those cases should not bind them in this case. So that is the principle. Hence, the petitioner's present actions to recover possession of the said properties from respondents on the basis of said judgments must fail. Okay, so they relied on the decisions of those other cases. Maybe, no, if this is correct, no, then if you're the lawyer, you might have no, siguro mag-regret ka ba, may pa akong gi-prove akong ownership again in this case, no, I should have introduced evidence to prove that I am the owner of this case, so that even if the decisions in the prior cases are not binding, there is still a factual basis for the grant of the relief for recovery of possession. Okay. Well, of course, the winning party who lost before the Court of Appeals was aggrieved, no? Not happy. Aggrieved by the Court of Appeals decision, the petitioners are now before this court, the Supreme Court, via the instant petition for review on certiorari. Okay. Remember, petition for review on certiorari, we discussed it earlier. Pure questions of law. Appeal by certiorari to the Supreme Court, Rule 45. So, they were not happy because they lost before the Court of Appeals after winning before the Municipal Trial Court in cities and after winning before the Regional Trial Court. When it reached the Court of Appeals, the decision was reversed and they lost. Ikaw basad ana, madto jud kay Supreme Court, di ba? So they elevated the case to the Supreme Court. So they raised two questions, two main questions. First was that the Court of Appeals committed an error according to them. Well, obviously, if they agree with the Court of Appeals, there is no reason to bring the case to the Supreme Court. So they should allege, or their position should be that the Court of Appeals committed an error when it held that the prior judgments declaring the petitioners in this case as the true and lawful co-owners of the property did not bind the respondents in this case, the defendants in this case, as they were not parties to the actions, saying that these were an action reivindicatoria and an action for recovery of possession, hence in personam, personal, and as such they bound only the parties properly impleaded. The opposite of this action in personam is the real action, no? And duly heard or given an opportunity to be heard, even if such principle is inapplicable in the instant case. The Court of Appeals impliedly ruled, no, that the respondents would have a better right of possession over the subject matter property versus the petitioners in this case, despite the rulings in the other cases, the decisions that were issued ahead of this case. Okay. What is the position of the Supreme Court? Okay. So, spoiler alert, they won. The Court of Appeals decision was wrong, and the decision of the Regional Trial Court and the Municipal Trial Court in cities was correct. Okay. So according to the Supreme Court, the petition before the Supreme Court, appeal by way of certiorari, Rule 45, question of law, the petition is meritorious. Basically, it is correct and it is proper, no? The issues raised in the instant petition boil down to the basic question whether or not the final and executory decisions rendered in the previous, separate case, previous action reivindicatoria, finding petitioners to be the lawful owners of the subject properties, are binding upon the respondents in this case. Is the decision in the prior case binding to the respondents in this case? So that is the issue before this Supreme Court. It's tricky. The court rules in the affirmative, meaning it finds it binding. At the outset, the court finds it proper to look into the nature of the actions filed by the petitioners against the respondents. What is the real substance of the action filed by the petitioners against respondents? So, a perusal of the complaints filed by the petitioners shows that the actions were captioned as action publicana and or recovery of possession. However, the Supreme Court agrees, sayop daw ang designation sa action. The court agrees with the ruling of the lower courts that the complaints filed were not action probationa but were actually action reivindicatoria. Okay. Now we will make a distinction. Okay. Action interdictal, the simplest one, probationa, and action reivindicatoria. Okay. In a number of cases, because this is a basic principle, no? Balik-balik lang ba? This court had the occasion to discuss three kinds of actions available to recover possession of real property. So there are three types of actions. So if you lost possession, if you were deprived of possession over your real property, like for example, there is a squatter, an intruder, you just left 1 week your land, then the next week when you went home, when you went back to your land, there is already a house, there is already someone living in the land, it is already fenced, so you lost possession, you were dispossessed, so you choose your remedy. The easiest for me would be action interdictal, either forcible entry or unlawful detainer. So if you were surprised that somebody was already occupying your land, that is action interdictal, forcible entry by way of stealth or strategy. Prescriptive period will be counted from that time or date, from the date of discovery or learning regarding your dispossession. If the dispossession was done by force, so the prescriptive period, the 1-year period, will be counted from the date of actual dispossession, because you have knowledge of the dispossession. It would be different if you are in the United States, you stayed there for 10 years, when you return to your land, somebody was already living there. That could be the time of discovery. Could be, okay? Okay, even if you're abroad, possible man, somebody reported it to you. So action interdictal comprises of two distinct causes of action. Listen to this, no? This is nice to know. I have read this several times when I was a student, but I still love to read it again. Action interdictal comprises of two distinct causes of action, namely forcible entry or detentation and unlawful detainer. This is a weak. In forcible entry, one is deprived of physical possession of real property by means of force, intimidation, puwersa or pasikrito, force, intimidation, strategy, threats, or stealth. Whereas in unlawful detainer, this is the typical case when you are renting your property and the renter, the tenant, will not leave the property even if he or she is not paying the rent anymore. Unlawful detainer, one illegally withholds possession after the expiration or termination of his right to hold possession under any contract, express or implied. Because in unlawful detainer, the possession of the defendant, the possession of the person depriving you of possession, started as legal when his right was terminated. Like for example, the lease ended or he did not follow the terms of the lease, the right to possess ended, so it became illegal. Unlike in forcible entry, you were threatened, they used force to enter the land, the possession of the intruder was illegal from the very beginning. Okay. The two are distinguished from each other in that in forcible entry, the possession of the defendant is illegal from the very beginning, and that the issue is which party has prior de facto possession. De facto possession is prior physical, factual, prior physical, material, and actual possession. Okay, it is not possession de jure, but possession de facto. Not legal possession, but actual, physical, and material possession. This is a common error, no? When you find these cases in the real world. Sometimes they file a action for forcible entry, then they rely on the title of the land. That is not proper. Although maybe the title of the land can explain why you are claiming recovery of possession, but you have to make sure that you have alleged and proven actual and physical prior possession. Okay? Possession of the defendant is originally legal but became illegal due to expiration or termination of the right to possess. This is unlawful detainer. Okay? May mga rent pa, default, hindi na mabayad ang abang. The jurisdiction of these two actions. Okay? The jurisdiction. In most cases, in cases involving recovery of possession, the jurisdiction is determined by the assessed value of the properties. But with respect to action interdictal, forcible entry, and unlawful detainer, it is not about the assessed value. The jurisdiction of these two actions, which are summary in nature, because these cases are governed by the summary proceeding, no full-blown trial, only position paper, lies in the proper municipal trial court or metropolitan trial court. Both actions must be brought within 1 year from the date of actual entry of the land. In case of forcible entry, unless if the forcible entry was done by way of stealth, no, pasikreto, so it is 1 year from the discovery of the dispossession. And if it is an unlawful detainer, from the date of the last demand, 1 year from the date of the last demand. That is easy, no? If malampas ka sa 1 year, mag-demand ka balik para magsugod o balik ang 1 year. In case of unlawful detainer, the issue in said cases is the right to physical possession, actual physical material possession, not legal possession. Okay, so the common principle of taking possession, possibly it cannot apply. Action publicana is the plenary action to recover the right of possession, which should be brought in the proper regional trial court. Jurisdiction is with the regional trial court. When dispossession has lasted for more than 1 year, it is an ordinary civil proceeding to determine the better right of possession of real estate, realty, independently of title. So, if the issue is prior physical possession, independent of title, if it is within the 1 year period from the dispossession, action interdictal. But if na-late ka ba, no? You lost the 1 year, so action publicana. Because this action is easier. It is just about possession. It is independent of ownership or title. So, ownership or title as a general rule is not resolved in these cases. But of course, there are exceptions. In other words, if at the time of the filing of the complaint, more than 1 year had elapsed since defendant had turned plaintiff out of possession, more than 1 year from the dispossession, or defendant's possession had become illegal, the action will be not one of forcible entry or illegal detainer, but an action publicana. Okay. So, muna itong istoryaan. No? Lampas ka sa 1 year, ma-dismiss mo na kay jurisdictional fact mo ng 1 year, imo mo na i-allege and you have to prove it. No? From within 1 year from the dispossession, or within 1 year from the discovery of dispossession, or within 1 year from the last demand. So, that is a jurisdictional fact. So, if that is not present, it cannot be established. The case will be dismissed. So, rather than, because the action interdictal, it is beneficial, especially if your clients are abroad, busy, because it is position paper, no? In lieu of trial, you just submit position paper. But with action publicana, it is a full-blown trial. They have to sit at the witness stand and testify. Okay. So, if you are late in filing, more than 1 year, action publicana, and your witnesses should sit in the witness stand and testify. But sometimes it's a good thing, no? Especially if the other party loves to lie, fabricate evidence. It's very difficult if you cannot cross-examine the witnesses of the other party. You cannot propound questions to the witnesses of the other party. If you think they have the penchant to lie, if you think that they have the pattern of lying in their affidavits, I would suggest, no, action publicana rather than interdictal. Let them sit in the witness stand and cross-examine the witnesses of the other side. Rather than action interdictal, lami kayo ilang testimony, kaya affidavit ragod. Yeah, di ka cross-examine. On the other hand, action reivindicatoria is an action to recover ownership, also brought in the proper regional trial court in an ordinary civil proceeding. So, the difference with action reivindicatoria and action publicana, although both are with the regional trial court, is the grounds, no? Because action publicana, it is independent of title, independent of ownership. So, it is like an action interdictal but filed after the 1 year period had lapsed. Action publicana is the late action interdictal. But if you rely on your title, like, this is my title, I do not have prior physical possession, but I have this title, action reivindicatoria. So, action reivindicatoria or action de reivindication is thus an action whereby the plaintiff alleges ownership over a parcel of land and seeks recovery of its full possession. So, this recovery of possession is anchored on your ownership. It is a suit to recover possession of a parcel of land as an element, no? As a part of the bundle of the rights of an owner, okay? As an element of ownership. The judgment in such a case determines the ownership of the property and awards the possession of property to the lawful owner. Remember, the prior cases were action reivindicatoria. This case, it was filed as an action publicana, but the court later on determined that this is not actually, when you scrutinize the complaint, this is not actually an action publicana, but it is actually an action reivindicatoria, recovery of possession dependent, no, or anchored on the plaintiff's title. Okay, so it is different from okay, nawala ko. So the judgment in such a case, no, determines the ownership of the property and awards the possession of the property to the lawful owner. It is different from action interdictal or action publicana. Amora po de. Gi-explain that there's a decision where plaintiff merely alleges proof of a better right to process without claim of title. So just actual prior material physical possession independent of title. Even if you are not the owner, if you had prior physical possession, di ka pwede papawaon diha. Dayon-dayon. Okay? Pwede ka papahawaon sa katunay title, but action reivindicatoria. Okay? On the basis of the above discussions, it is clear that the lower courts did not err, okay, in ruling that the suits filed by petitioners are action reivindicatoria, not publicana, as petitioners seek to recover possession of the subject lots on the basis of their ownership thereof. Proceeding to the main issue in this petition, there is no dispute that the regional trial court's decision and the Court of Appeals decision in the prior cases used by the Municipal Trial Court in cities, Metropolitan Trial Court, in the present case as basis in holding that herein petitioners are owners of the subject properties, are thus entitled to legal possession thereof, are judgments on a previous case for action reivindicatoria which was filed which was filed by petitioners against persons other than herein respondents. So that is the tricky part here, because in those previous cases it was an action reivindicatoria. The decision declared the plaintiffs in this case that in the prior case the ruling was that the plaintiffs in this case are the owners of the land. However, in the previous case there are different sets of defendants. In this case, the defendants in this case, the respondents in this case, are not part of the previous action reivindicatoria. So the question is, are the decisions of the prior cases binding to the defendants, the respondents in this case? Okay. It is a settled rule, no, that a judgment directing a party to deliver possession of a property to another is in personam. Okay? It is conclusive not against the whole world. No? In personam, ang opposite niya in rem, dili real action. In rem. Nasayop to ganina. In personam, in rem. It is conclusive not against the whole world, but only between the parties and their successors in interest by title subsequent to the commencement of the action. An action to recover a parcel of land is a real action. Okay. So, mo to'y difference, no? In personam, binding only to parties who are part of the case. Action in rem, it binds the whole world, even if you are not part of the case. No? Even if you are not part of the case, it will bind the whole world. So, it will include persons who are not parties to the case. That is an action in rem. Action in personam, the decision will only affect the persons who are parties to the case. So, an action to recover a parcel of land is a real action because it involves realty. Okay? But it is an action in personam, for it binds a particular individual only, although it concerns the right to a tangible thing. Any judgment therein is binding only upon the parties properly impleaded, okay, where the court has acquired jurisdiction of the parties by way of summons, okay, and duly heard or given an opportunity to be heard. Syempre, you will only lose the case if you were given the chance to be heard. If you did not even know that the case was existing in the first place and suddenly you just lost, it would be unfair, diba? However, this rule admits of the exception that even a non-party may be bound by the judgment in an ejectment suit. Okay? So this is something nice to know, no? Where he is any of the following. Okay. So even if he or she is not impleaded, the judgment in an ejectment suit may bind a person, even if he is not impleaded, if he is any of the following: trespasser, squatter, or agent of the defendant fraudulently occupying the property to frustrate the judgment. Okay, so you will appreciate this. This is typical, no? This happens in the real world. Let's just say me, I'm the complainant, I sued you, Pedro. The problem is, Pedro realized he's losing the case. So in the middle of the case, he would ask Juan to go inside, Peter to go inside, Bobby to go inside. And during the decision, when Pedro lost, the occupant was already Bobby, Bill, Bong, okay, Charlie, persons who were not impleaded in the case for ejectment. So what will happen? Do I have to file another case for those other persons? And when I will be winning the case already, or when I will win the case already, it is already another person will be in there, Tom, Petra, different persons again. So I have to file another case. So that is the spirit behind this exception. Trespasser, squatter or agent of the defendant fraudulently occupying the property to frustrate the judgment. Okay, maro ba? That is funny, but in the real world, that happens. The guest or occupant of the premises, with the permission of the defendant, transfere pendente lite. So pending the litigation, somebody moved in. Okay, sublessee, colessee, member of the family, relative or private of the relative or privy of the defendant. So basically, let's say the defendant is a lola. This lola has 20 children. Gradually, the children, the grandchildren, the apo sa tuhod are occupying the land. Yeah, that the case for ejectment lasted for 3 years. After 3 years, lola lost. Lola died. But all his grandchildren, all his apo sa tuhod, and the in-laws are in the land already. These persons were not impleaded in the original case. Do you have to file the case again? Okay. So that is the spirit behind the exception, where although it is an action in personam binding only upon the parties impleaded, it admits of exception. Of course, so that there will be no mockery of the proceedings. Okay. In the instant case, the court finds no cogent reason to depart from the findings and conclusions of the MTCC, the municipal court, as affirmed by the regional trial court, that the respondents, the intruders, are mere intruders or trespassers who do not have a right to possess the subject lots. Thus, they fall within the exception, okay, where even if they were not impleaded in the original case, the decision binds them, okay. Thus, the court adopts the decision of the municipal court, the MTCC, on the matter, to wit. On the other hand, the evidence for the defendants showed that they are mere intruders on the lots in question. Okay. They are occupying their respective portions simply as places to stay, with the intention of acquiring the said properties in the event that they are public lands and not owned by any private person. So, isuway lang ba, puyo-puyo og dugay, basin dahil wadyo mo angkon, may ilahan na, no? Taking chances. It is noted that while the defendants had declared the houses and improvements for tax purposes, so meaning there are tax declaration certificates covering their houses, because if you are a squatter and professional squatter, you have to do this, diba? Because it will establish the date of your occupation. the first tax declaration, that is a black and white paper. It will establish the date of your occupation. So later on, more than 30 years, you can acquire the property possibly, no? Assuming that the requisites are present. So although their houses and improvements were declared for taxation purposes, not one of them had declared in his name the lot in which his house or improvement is built thereon. Okay? So they only declared under their name the improvements, their house, but not the land where they built their house. Okay? They just waited for the complainants to show proof of their ownership of the lot. No? Gahuwat na sila ba? It was indeed revealing that while professing that the lots are public land and the defendants never bothered to apply under any of the legal modes of acquiring land of the public domain for the portion occupied by them. Wag gusto magpatitulo ba? Obviously, their physical possession of the premises was not under claim of ownership or in the concept of an owner. So, kato dito, puyo-puyo rato ila. They were not, because when you occupy a land, when you possess a land, you have to make a distinction. Are you there as a lessee or as a mere illegal user or intruder, or are you possessing and occupying the land in the concept of an owner? Okay? So you have to make that distinction. Hence, the defendant's possession cannot ripen into ownership by prescription as claimed by them. Amo na niya akong sulti. Because for the prescription, remember in their answer, they had this magic figure, 30 years, that they possessed and occupied the land for more than 30 years. That is the magic figure, because 30 years is the required period of possession and occupation for acquisitive prescription to set in. Okay, you will own the land because you have occupied and possessed that land for more than 30 years, or at least 30 years. Whether you are in good faith or in bad faith, you will occupy that land for so long as it is not titled. You will possibly own that if all the elements are present. That is what you call acquisitive prescription. However, the requirement is that the possession must be open. Dili pa tago ba? Dili pa sikreto. Buat day ka og house, but it was a basement, no? When you look at the land outside, it is as if there was no house, because your house was beneath the natural ground level. It was a tunnel. So that is not that is possibly that will not satisfy the requirement, because the requirement is that not just mere possession and occupation. It must be open, continuous, exclusive, meaning to the exclusion of all other people, notorious, well known ba, no? Ilado, notorious, and it must be in the concept of an owner. Okay. The plaintiffs in this case pray that the right of possession of the lots is entitled to protection under the law. The evidence showed that the defendant's entry into and possession of the disputed premises was illegal from the beginning and to remain to be so until present. So illegal from the start, illegal until the end. Okay, there is no question therefore that as between plaintiffs and who had been judicially declared the owners of the land and the defendants who are mere squatters therein, intruders, the former are entitled to such legal protection. So on the basis of the foregoing, okay, respondents being trespassers on the subject lots are bound by the said judgments. So they fall within the exception where, although the real action was an action in personam, which binds only the parties impleaded to the case, were given the right to be heard, to defend themselves in the prior action for vindicatoria. Those cases will bind them because they fall within the exception where they are intruders, okay, or trespassers. Respondents being trespassers on the subject lots are bound by the said judgments, which find petitioners to be entitled to the possession of the subject lots as owners thereof. So, as you can see, the error of the Court of Appeals is not also it is an error of judgment but not a blunder, no? It is also tricky. Imagine, because there is also a good solid justification of the Court of Appeals decision, in which case, according to the Court of Appeals, the prior cases were action revindicatoria, meaning a real action involving real estate, but although it is a real action, it is an action in personam. It will only bind the persons who were impleaded in those prior cases. The defendants were not parties of those cases. They are defendants in this case, but they were not parties in the previous case. Okay? They were not parties in the previous case. So, the ruling of the Court of Appeal said that the previous cases, considering that the defendants in this case were not parties to these previous cases, the decisions in those prior cases should not bind the defendants in this case. I think the logic is also solid, no? But as we have read now, before the Supreme Court decision, it was wrong. Because, although that is the general rule, there is an exception. Except if the defendants in this case are intruders, squatters, or persons occupying the land to forfeit, to make a mockery of the prior proceedings, no? Let me find the exception. Trespasser, squatter, or agent of the defendant fraudulently occupying the property. Okay, the keyword was to frustrate the judgment. Frustrate the judgment in the prior cases. Okay, so because the defendants in this case, possibly they are like apo, sons, nephews, nieces, tenants of the parties in this case. So if you will not provide, if this exception is not honored, if this exception is not available, recovery of possession would be a never-ending task. No, it will never end, because every time a case is almost decided in favor of the landowner, they can just change the occupant, sell their rights to occupy the land, and there will be another defendant in another case for action reivindicatoria or any other action for recovery of possession. So it will be easy to frustrate the judgment. Okay, or like during the time when the landowner is almost winning, they accepted new guests, they accepted new lessees, tenants. So does it mean that the landowner has to file another case to these new occupants, new trespassers, new intruders? No, because there is an exception, as I have just read to you. Okay, there is an exception that even a non-party may be bound by the judgment in an ejectment suit, where he is any of the following: trespasser, squatter, or agent of the defendant fraudulently occupying the property to frustrate the judgment, guest or occupant of the premises with the permission of the defendant. So basically, anyone occupying the land with the consent, the short version ba, with the consent or by design of the defendant in the other case. Okay, so this is a good ruling with respect to the exception, no? Because as a general rule, a decision in a case should bind only the parties to the case. But this exception is also wise and fair. Otherwise, a landowner will not do anything else but always file a case for recovery of possession, because every time that he or she will almost win the case, there will be another occupant, another guest, another lessee, another tenant, another intruder, another trespasser. So this exception is very justifiable and very proper. No? Imagine if the exception is not present. Every time you are winning the case, they can just replace the occupant, replace the possessor, and there will be another person and file a new case again. It's just unfair. Okay? So I hope you learned with me in this reading of the Supreme Court decision. A very interesting case. No? Simple and basic lessons and theories in law, but there was a tricky part, whether or not the decision in a prior case where the defendants in this case were not parties to the prior case, will that decision, being a decision in an action in a real action, which is an action in personam, will it bind the defendants in this case who are not parties to this case, who are not parties to the previous case? That's also something nice to know, no? A nice learning from the Supreme Court decision. I find the decision in this case very nice and just and fair. So I hope you learned something with me, and I'll see you again in another video. Thank you.